The Karnataka High Court has put out a judgment in the matter of Franklin Templeton shutting down winding up the 6 debt schemes earlier this year. Remember, on 23rd of April, Franklin Templeton had said that they are winding up 6 of their debt schemes owing to lack of liquidity in the bond markets and due to redemption pressures. The 6 schemes that were wound up include Franklin India Low Duration Fund, Dynamic Accrual Fund, Credit Risk Fund, Short-Term Income Plan, Ultra Short Bond Fund and Income Opportunities Fund. This had of course had an impact on over 3 lakh unit holders who had said that their consent was not taken before winding up these funds, and that is something that they were not okay with. The matter was taken to court and now Karnataka High Court has given out the ruling. So what is the order and judgment by Karnataka High Court? Well, Karnataka High Court maintains that there is no interference in the actual decision of the trustees that they had decided to wind up the fund, so there is no interference in that matter. But although they are okay with that decision taken by the trustees, they maintain that this decision to wind up the 6 schemes should not have been done without the consent of the unit holders. So they have said that no further steps or anything cannot be implemented until a simple majority is taken from the unit holders. So that is a big win coming in from the unit holders for the unit holders at this point in time. They have said that it will be open for trustees to obtain consent of the unit holders and take further steps in according with clause 3 of regulation 39 of mutual fund regulations. Now also they have directed SEBI to ensure that forensic auditors submit their report to SEBI, and the SEBI chairman or SEBI has to go through that forensic audit report and give out their findings within 6 weeks of the submission as well. So these are the points that they have laid out, but very importantly, Karnataka High Court has made comments on the role of SEBI in this matter. What they have said is that SEBI should have been more proactive and SEBI has failed to perform its duties. So that's a huge comment coming in from Karnataka High Court on the role of SEBI and what SEBI ought to have done. They have made these strong comments against SEBI. So at this point in time, they are saying that the forensic audit has to be submitted. They are saying that a consent has to be taken from the unit holders and that SEBI should have acted more proactively. SEBI should have paid more attention to what was happening. The order judgment also mentions that SEBI was not aware of what was happening in Franklin Templeton, etc. So quite a few points of contention on that front as well. At this point in time, the operation of the judgment by Karnataka High Court has been stayed for 6 weeks as that request had come in. So there will be no redemption during this period. Trustees and Franklin Templeton cannot make any borrowings or clear any liabilities during this period is what Karnataka High Court has said. In response to the High Court order, Franklin Templeton has said that the court has upheld the authority and decision taken by the trustees to wind up the schemes. So they have mentioned that the court has upheld the decision to wind up the scheme, but they have said that the unit holders will be required, the approval of the unit holders will be required. Franklin Templeton so is saying that we are considering the order and will take appropriate steps in consultation with our legal experts in the best interest of the unit holders. So we will have to wait and watch whether further representations are made in the Supreme Court from either Franklin Templeton or if any objections are raised from side of SEBI on the comments that were made by Karnataka High Court, and if this matter goes to Supreme Court as well, in that case it will go on and on. But as of now, Karnataka High Court clearly saying that the consent of the unit holders is required.